Well, that good-for-nothing gadfly has finally gotten around to doing something. I'm going to discuss in this series the law of nuisance, free speech, and touch upon Monell actions. I spent about 13 years in court, state and federal. The first action started out as a New York State Article 78 special proceeding of a zoning board determination. The details of this aren't really important. They're kind of ancillary to the points that I'm trying to make here, but the basic facts of the case, which are established as a matter of record, are these. I live in a single-family residential district, upstate New York, 40-foot wide lots. This one is approximately 183 feet deep. The neighbors to my immediate south had a 60-foot wide front and about 183 feet deep. And between the two houses, two-story single-family residential dwellings, there's a driveway that was theirs. It's about 16 feet wide. And this includes a sidewalk on their side of the driveway, a retaining wall, a 3-foot side yard, and then my house. Well, I used to be a blues musician. And one day, several of my friends came up and we started playing blues music, and the neighbors didn't like it. And they called the police, and the police came into my house and essentially made me stop playing music. So as a form of retaliation, my neighbors decided to do two things. Well, actually, three things. One of the things they did was they tied two German Shepherd dogs to their property line. And then one of the dogs had puppies, so there was incessant barking. We complained about that, and they decided to build a basketball court between the two houses. So what I did was, rather than suing them directly in court, I went to the zoning board and filed a complaint saying that the use of land was not allowed. And under zoning law, what you have to do is when you wish to deploy a use of land that is not allowed, you have to get a variance. In this case, it would be a use variance. Well, the zoning board didn't know what to do because the position of the police department was anywhere from, well, we ain't going to tell some kid he can't play basketball in his own yard. Or, Mr. Dino, this is not the Soviet Empire. We can't go around just arresting people for playing in their yard. So the zoning board, rather than following the strict construction of the zoning ordinance, which is what they're supposed to do, took advice from the village attorney, who told them that the basketball structure is more than 5 feet from my property line. So it is not in violation of the setback rule, which is an area. It involves area rather than use. In other words, it's kind of like saying, well, it ain't murder, you know, when it's robbery or fraud or something like that. Well, anyway, The zoning board decision was this little tiny decision. It was like a few lines long that said, well, the use is not a structure or something like that, and it does not violate the setback rule or something. So I brought an Article 78 special proceeding to have the decision vacated, and to hopefully have this declared as a zoning violation, as a non-permitted use of land. Well, what the village attorney decided to do was he decided to replace the zoning board decision with his own decision. So what you had was the zoning board decision and this other thing that he wrote. So what he wrote was not anything that was decided by the zoning board. It was just something that he submitted to the judge. In other words, he falsified the zoning board record. And in fact, prepared attorney's affidavits claiming that his decision was actually the zoning board decision. Well, had the judge paid close enough attention to this, he would have seen that this was obviously not the decision of the zoning board. And in fact, he acknowledged that in his decision, but decided to dismiss my Article 78 proceeding, and decided to go with the village attorney's decision, which essentially said that the use of land was permitted because it was a customary use of land. Now, this completely ignored the fact that in the law of custom, you could have a good custom and a bad custom. For instance, in civil rights cases, you have situations where it's customary for there to be a segregated lunch counter. And it's undeniably a custom, but that doesn't mean it's a good custom. It means it's a bad custom, and if it's a bad custom, then it ought to be enjoined. All of that is straightforward common law. All of this was ignored. So what I had was this judge's decision, which I appealed to no avail, and which I attempted to appeal to the New York State High Court to no avail. So what I was left with essentially was the Village of Johnson City maintained a policy based on a judge's order that was obtained by fraud, supplanting the actual zoning board determination with that of an attorney, as the basis of a policy which essentially said that a village, a municipality, which is a corporation under the law, has the right, has the prerogative, actually, to determine by not the strict construction of the zoning ordinance, but by an interpretation of the zoning ordinance, saying that a particular use of land, which can be a private nuisance, is legal and therefore cannot be prosecuted under the zoning ordinance. So what I did was I brought a federal case. And I essentially put this federal case in the form of a Monell action, which is something that was devised in the late 70s and in 1980 with in 1980 Owens versus Independence, Missouri, which was the first time that the U.S. Supreme Court declared that a person injured in fact may bring a suit against a municipality, because up until that time, municipalities were protected under the doctrine of governmental immunity. Now, on the other side of this, you have a case called FCC versus Pacifica. And it might not be apparent what these two things have in common. But what they do have in common is that the decision in FCC versus Pacifica was, in essence, legislation from the bench. Justice Stevens, who was appointed by Gerald Ford to replace William O. Douglas, wrote the decision for actually a three-person minority. Two guys went along with it to make it a 5-4 decision, FCC versus Pacifica, which is based on the idea that if a child turns on the radio and hears George Carlin's filthy words routine or anything using those words, that this will somehow injure the child or somehow endanger the child. And to avoid the issues pregnant in this sort of proposition, Stevens merely said that if a child turns on the radio outside the hours of 10 p.m. to 6 a.m. and here's the word fuck, cocksucker, whatever, shit, piss, it'll constitute a public nuisance, even though the radio is inside of a private residence and can be controlled with an on and off switch. There's some sort of unproven effect that these particular words have on some person at some undetermined age. Someone that is less than an adult, because it was brought up in the dissents that the decision was not designed to protect weak-minded adults. It was somehow designed to protect children, even though there was no legislation on which this decision was based. It was merely based on action taken by the Federal Communications Commission. Anyway, this is where the whole idea of the kids, we got to do it for the kids. Oh, my kids saw that. What if my kids see this? What if my kids hear this? Oh, we can't have that because of the kids. This is where all of that came from. It had to do with broadcasting. Let me continue this on the next